Moving on to video number 2, I would request Sweety if you can explain in little detail the provisions, salient provisions of this Act of 2002.
I will try my best to explain the whole PMLA Act in just 4 to 5 minutes, because it is actually a very detailed act. And firstly, in order to understand this act, it is important to understand the whole structure of the PMLA Act. So, as far as the structure of PMLA Act is concerned, it has 10 chapters divided into 75 sections, and the most important part of the PMLA Act, considering the structure of the PMLA Act, is the schedule that has been annexed with this PMLA Act, because in this schedule there are 3 parts, part A, part B and part C, and there are list of offences that has been specified in this schedule, and these offences are known as scheduled offences. Now, just like initially I had explained about the illegal money that the money launderer tries to launder, that illegal money under the Prevention of Money Laundering Act is known as the proceeds of crime. Proceeds of crime is defined under section 21U of the PMLA Act. If I may refer that section for the future faculty, I think it will be beneficial for them. So, section 21U, it states that proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offence, or the value of any such property, or where such property is taken or held outside the country than the property equivalent in value held within the country or abroad. So, please note that proceeds of crime means any property that has been derived by any person as a result of criminal activity relating to a scheduled offence. Now, if we read the explanation which has been attached to this section, it says, for the removal of doubts, it is hereby clarified that proceeds of crime including property not only derived or obtained from the scheduled offence, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offence. So, there has been discussions between the meaning of criminal activity relating to the scheduled offence and criminal activity relatable to the scheduled offence, because there was a view that relatable means able to be related to the scheduled offence, but this confusion had been cleared by the Honorable Supreme Court of India in the recent Vijay Madan Lal Chaudhary judgment, which had been decided on 27 July 2022, and the Honorable Supreme Court had observed that both of the meanings, explanation is basically the more detailed meaning of the main part of this section, and there is no difference between the words relating to or relatable to, that is just an adjective, and the main meaning of proceeds of crime is any property which has been derived out of any criminal activity concerning the scheduled offence. So, any criminal activity that is concerning the scheduled offence is there, and any property is generated out of such criminal activity, that will be considered as proceeds of crime. Now, the next question could be, what is money laundering? So, money laundering is when the money launderer tries to launder this proceeds of crime which I have just explained, and money laundering has been defined under section 3 of this Prevention of Money Laundering Act, and if I may read that section as well, I think it will be beneficial for the future faculty. It says, whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected to proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property, shall be guilty of offence of money laundering. So, for the money laundering allegations, it is sufficient that if any person is in any way related to any process or activity related to the proceeds of crime. So, if any person in any way is related to the proceeds of crime, like in the way of acquiring it, or if some person is possessing it or concealing it, or either projecting or claiming it as untainted property, then the money laundering allegations can be set up against such person. Now, in order to understand this act in a more better way, there will be another question like what can be the prescribed actions which the authorities under the PMLA Act can take. So, the prescribed actions are basically the powers of the authorities under the PMLA Act, and the main powers are first powers of attachment, secondly powers of search and seizure and survey, third power to arrest, and fourth power to summon and record the statements under section 50 of the PMLA. I will start with powers of attachment very briefly. So, powers of attachment are given under section 5 of the PMLA. And the important point to be noted under section 5 of the PMLA that it is not an arbitrary power, and proper reasons to believe has to be given by the authorities specified under the PMLA who may attach the proceeds of crime, and the reasons to believe has to be with respect to the fact that any person is in possession of any proceeds of crime, and such proceeds of crime are likely to be concealed, transferred or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter. So, if the officer or the authorities as mentioned under this act has the reason to believe on the basis of material in his possession that any person is in possession of the proceeds of crime, and if the attachment is not done, such proceeds of crime is likely to be concealed or transferred or dealt with in any manner which will ultimately affect the ultimate aim of the PMLA Act, that is confiscation of the proceeds of crime, then in that case the officer may go for provisional attachment order. He may issue the provisional attachment order. I would like to reflect on the procedure as well after attachment. For the better understanding of the future faculty, this provisional attachment order remains in force for a period of 180 days, and if this 180 days have to be extended, then interference of adjudicating authority is important. So, for the 180 days period, the provisional attachment order is provisional, and after this within 30 days the officer had to file the original complaint before the adjudicating authority, and at the level of adjudicating authority proper opportunity of being heard is given to both the parties in order to decide whether the property is actually involved in money laundering or not, and show cause notices are issued to any persons who have an interest in the attached property, and if it is decided by the adjudicating authority that yes, the property is involved in money laundering, that then it can confirm the this provisional attachment order. Now, the next question could be what is the duration of the attachment order after it is being confirmed. So, this duration is given under section 8(3). This attachment order which has been confirmed exist for a period of either 365 days or during the period of any proceedings that has been conducted under this act. Now, very briefly after this discussion, I hope I am able to give a clarity on the powers of attachment. Now, I would like to come on the power of search and seizure and survey. Power of survey is given under section 16 of the PMLA, and power of search and seizure is given under section 17 of the PMLA, and for exercising even these powers, proper reasons to believe have to be recorded by the authorities as specified under the act. Now, I would like to state the fact that this attachment process is a civil proceeding, and there is another procedure for criminal prosecution of the money launderers under the PMLA Act. So, for prosecuting the money launderer, the officer had to file the prosecution complaint before the special PMLA court. I would like to state that special PMLA courts are appointed for the purpose of dealing with the offences of money laundering under section 44 of this PMLA Act. So, once the proper prosecution complaint has been filed, then proper trial procedure is followed in order to decide whether the offence of money laundering has been committed or not. Now, one of the more important provision that has been given under section 44(1)(c) is about the committal of the proceedings relating to the scheduled offence to the special PMLA court, because sometimes there has been practical difficulties for committing the scheduled offence case from that very specific trial code to the special PMLA code. For example, this trial code may say that I am the specific code for this particular scheduled offence. So, why I should transfer this scheduled offence case to the special PMLA code. So, these are the practical difficulties which come up, but there is a recent judgment of Rana Ayub, and it has been decided that if there is a case of scheduled offence and there is a money laundering offence, the scheduled offence case has to be committed to the special PMLA code. So, this is about committal. Another question that may arise in the minds of the viewers who are the future faculty is about the CRPC provisions, whether these provisions are applicable to the money laundering offences. So, for this section 65 under PMLA is clear that CRPC provisions will be followed, but if there is something inconsistent in these CRPC provisions with the provisions of the PMLA Act, then in that case PMLA law will prevail. And also this is a settled law position that whenever there is a difference of opinions between the special law and a general law, then special law always prevail. So, in that sense also the PMLA provisions prevail. CRPC comes to the rescue only when there is no provision specified under the PMLA Act. So, this is about the CRPC provisions as well.
Thank you. This would be very useful for further understanding of this law. Now, the Act of 2002 speaks about ECIR. Now, would you like to explain the difference between the ECIR and the FIR, what is its significance and the purpose?
Right. The provisions of FIR are specified under section 154 of CRPC, and it is mandatory to supply the copy of FIR to the accused person. But as far as ECIR is concerned, the full form is Enforcement Case Information Report. ECIR is an internal document of ED, and it is not mandatory to supply the copy of ECIR. So, there has been discussions even on this, whether the copy of ECIR should be provided to the accused person or not, but in my opinion these copies cannot be provided, and even the Honorable Supreme Court in the recent Vijay Madan Lal Chaudhary judgment of 2022 have clarified this fact that ECIR is an internal document and it is not required to supply the copy of ECIR to the accused persons. Also, because money laundering is e-money laundering, these are such grave and adverse offences that if initially the allegations are disclosed to the accused person, and if we try to balance between the rights of fair investigation and rights of accused, this is my opinion that I think the balance weighs in favor of the rights of fair investigation, because money laundering can be done just at a click of the mouse, and in order to save the country from further offences of money laundering, it is important to deal with the money laundering investigations very well.
That takes us to the aspect relating to as to what would be the proper study material for a student of this subject and for the teachers of this subject, so that they can get a practical understanding of money laundering law, and also mention if there is any useful case law that is available by now.
Right. So, as far as the practical understanding of money laundering law, that is PMLA Act 2002 is concerned, I would like to recommend the future faculty to read first the legal news related to the ED cases, because once you read the legal news, you will come to know about many powers of ED, like the powers that I have discussed, like powers of attachment, powers of arrest, and you will come to know the relevant sections. So, once you read these legal news, you can refer to any legal news channel like Live Law and Bar and Bench, and once you have gone through these legal news channel, you can refer the BEAR Act first. So, for the future faculty, it is very important to be thorough with the BEAR Act first, because if you will not read the BEAR Act, you will not understand any news that is going on in the media. As far as the books are concerned, there are commentaries on the PMLA Act, like there is this commentary by Justice S.K. Sarvaria, there is this commentary by Dr. Shamsuddin, and you can also search for other commentaries as per your own wish, and you can refer any one of the commentaries to get the detailed knowledge of the PMLA Act. Now, as far as the important case laws are concerned, there are different kinds of case laws on different questions of law. Like on the point of law of bail under the PMLA Act, because section 45 of the PMLA talks about the twin conditions which are required to be fulfilled in order to grant bail in a money laundering case. So, on that point of law, the relevant judgment is of Nikesh Tarachand judgment, and after that judgment there has been amendment in section 45, and there has been another case after Nikesh Tarachand judgment, that is the case of Dr. V.C. Mohan, and there is one more very recent case of February, if I may remember. It is Directorate of Enforcement versus Gopal Reddy and others. So, you may refer these case laws on the point of bail. Also, another important judgments on some of the point of laws is the Axis Bank judgment, Opta Circuit judgment. You can refer all of these judgments, and if you want to understand the whole meaning and detailed knowledge of PMLA law, you can refer to the Vijay Madan Lal Chaudhary judgment, which is very detailed. It runs in around 530 pages. So, if you are able to understand that judgment, I think you will get good hold on the Prevention of Money Laundering Act.
Thank you, Sweety. You have been very informative and successful in explaining the purpose of this law. This brings us to the end of second video, and in third video we would start with the connection of money laundering with other offences, like say for example relating to narcotics, terror, etc. Thank you.
Thank you.